Your treating doctor tells you that he'd be happy to testify in your case when it goes to trial. 2 years later, your case comes up for trial, and now you reach out to him again and remind him what he said 2 years ago, that he'd be happy to come in and testify. He now tells you, hey, listen, I want nothing to do with your case. Nothing whatsoever. What do you do now? Can you still go forward with your trial? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Now you've got a problem. You were relying on your treating doctor to come into court to testify on your behalf, to explain to the jury how your injuries have affected you on a daily basis, to explain to the jury why your first doctor treated you improperly, and why those treatments were violations, basically violations from the standard of care. And that's what caused your injury and harm. And now your case comes up for trial. It's 2 years later, and you reach out again to your doctor because you want him to be prepared. You now have to let him know that your case is coming on, and he has to set aside a day to come into court and testify. And you know what he says? He says, I want nothing to do with this case. I'm not coming in to testify. I don't care if you subpoena me. I don't care what you do. Don't call me. Don't subpoena me. I'm not coming in to testify. Now you're stuck. Now your attorney can always serve a subpoena on your treating doctor. This doctor who's been friendly to you, who's been helping you get better over the past few years. Well, guess what? That's not the best strategy. Well, if your attorney subpoenas your treating doctor into court, guess what? He's not going to be a friendly witness. In fact, he'll probably be hostile. He'll be upset having to take time out of his day seeing patients and now come in to testify when he clearly didn't want to. And that's not the ideal scenario. You don't want a hostile, friendly witness because he won't be friendly anymore. So now he's not going to be giving you favorable testimony, although he will still have to testify factually about what's contained in your records. But that's only half the equation, to talk about what he did, what he saw, and what he observed. The doctor's not going to give any medical opinion. He's not going to frame those statements in a way that's really favorable to you. Now you've got a problem. Now your attorney has to do one of two things. He has to ask the judge for additional time to allow you the opportunity to get another doctor to come in and testify, an expert witness, or he now has to try and convince the doctor that he really should come in as he promised to do 2 years earlier. Those are the only real two options you have available. And your attorney is now going to have to scramble before the trial comes up, before the trial starts, in order to make this happen. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I recognize and I understand you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need answers, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.